The Federal Court today has found that Coles Supermarkets Australia has made misleading or false representations in down tickets in the proceedings taken by the ACCC. The proceedings related to 245 common products sold by Coles. The ACCC alleged that Coles temporarily increased the price of each product for a relatively short period of time before placing the product on the down promotion at a price that was still higher than or the same as the previous price before the price increase. The ACCC alleged the discounts were illusory and false or misleading in breach of the Australian consumer law. The hearing concerned an agreed list of sample products from the 245. The court has found in the case of 13 of the 14 down tickets that those were misleading in breach of the Australian consumer law in this liability hearing. The ACCC welcomes the finding by the court that Coles breached the Australian consumer law. We took these proceedings because we were concerned that the Coles promotional pricing practices in the down program were making it hard for consumers to identify genuine value for money in their purchases of essential products. We received complaints from consumers. We know how important it is for consumers to obtain real value in their supermarket purchases, so we decided to test these pricing practices in court. These proceedings and these findings have increased the transparency and delivered accountability for the Coles down pricing program. The court will proceed to make penalties and other orders at a later date. It is very timely for all retailers, particularly as we lead up to end of financial year sales, to ensure that they make accurate pricing and discount claims. The ACCC will continue to take action wherever needed to protect consumers from misleading or deceptive conduct. I'm now happy to take questions. I do note that these proceedings concerned the Coles down program. These were specific facts and allegations and findings in those proceedings. The Woolworths program case and judgment remain reserved, so I will not be able to make any comments in relation to the Woolworths program.
The fuel crisis will lead to a flow-on effect at our supermarket shelves. We are expecting prices to go up. What should we as consumers and what should supermarket giants look out for going forward?
We are conscious, and you will be aware, we are closely monitoring the fuel impacts on the fuel supply chain, a level of prices and impact on consumers. What is important is that if there are appropriate cost increases to pass on, is that retailers are absolutely accurate about the level and the impact of the fuel price increase and do not mislead consumers as to the reason for price increases.
Gina, what do you think this means for consumers? In the judgment, it said Coles was justified in its price increases. It got all the requests, but the judgment did say something about sort of measuring consumer harm, because they could potentially have been worse off had that 12 weeks, which is now kind of the precedent, actually been set.
I think there are a couple of important points from those aspects of the judgments. The court has sought to identify in what respect it's misleading, and it has drawn attention to both the genuineness of the was price, that is the increased price, in the commercial circumstances, but also in the circumstances of the promotion. What is the ordinary consumer's understanding of the promotion, and what is a genuine period and genuine representation of a discount? So we always need to come back to the facts and circumstances and the ordinary consumer's experience of the particular promotion.
Qantas was fined $100 million for misleading conduct. There was ghost flights, also an ACCC case. Would you expect a similar penalty to Coles?
The level of penalty is a matter for the court to determine. The ACCC will seek a substantial penalty reflecting the importance of accurate pricing for consumers, and also because it is very important that a penalty is not just able to be dismissed as a cost of doing business, and that it becomes at a level that is a significant deterrent for such conduct.
Do you think this could be a bit of an end for was pricing? And it's not verbatim, but I believe the ACCC's guidelines beforehand is saying that was pricing is a bit risky in a lot of circumstances.
It is capable for retailers to present a genuine was price to compare to a price discount. And we would expect retailers to continue to seek to present genuine discounts to consumers to attract them to purchase. It's in fact the stuff of competition, that you have genuine pricing claims and genuine discount claims. And it's an important point that such misleading conduct not only harms consumers, it harms law-abiding competitors. So there is a consumer harm and a competition harm that the ACCC is concerned about.
And are you happy now that there's sort of a precedent set in terms of the amount of time?
We are happy that, first, we are happy that the court found there was misleading conduct in relation to 13 of the 14 sample tickets. We also consider that there has been very important analysis here of the various levels at which the ordinary consumer understands a price discount claim. We do note that this time period is specific to the judge's analysis of this promotion in these circumstances.
Given this ruling, do you think Coles should retire the down discount promotion?
That will be a commercial decision by Coles. There is, on all the evidence we have seen, a true value that consumers place on genuine discounts in a long-term stable price discounting program, but that will be a decision by Coles.
And should the CEO apologise, again, given these court findings?
Again, it is important for Coles and the CEO to make decisions about accountability to their customers.
I know you can't comment on the Woolworths case, but will this set a precedent for the other supermarket?
I'm not going to make any comments that might be seen as reflecting on the Woolworths case.
You said that it's important retailers have genuine discounts in this lead up to the end financial year. Are there any specific investigations that the ACCC has underway in this area?
We've previously talked about the December 26th, so the Boxing Day sales, and also the Black Friday sales, where we have done sweeps and have identified areas of representations that were concerning to us about accuracy, both as to level of discount, as to representations that it was whole store-wide sales when it was not. There were a range of concerning practices, and we are continuing investigations in that regard.
We might leave it there.
Sorry,
Just one second, Geisha. We've got someone on the phone from Melbourne.
Sorry.
Go ahead.
Sorry. Can I just ask, one of the things that was mentioned in the judgment was that there had been an internal policy at Coles up until March 2022 for products to be at a stable price for 12 weeks before getting these discounts, and that was done away with because of competition or perceived sort of pressure from Woolworths and their other direct competitors. How important is it for Coles and other retailers to not be letting the consumers get stuck in the middle of these wars that they're having with each other?
This is a good example of where competition is at work, and that firms still need to very carefully consider what is the understanding of the ordinary consumer. Firms should continue to give discounts and to choose the programs they place the discount promotion in, but it has to be accurate and well understood by consumers, given the consumer's understanding of the program and promotion in which they place it.
Thanks very much. That's all I have.
Just
Pleasure.
Lastly, roughly, what sort of penalty is Coles expected to receive? 9 figures?
I'm leaving that entirely for the court. We will certainly make strong submissions on the level of penalty.